So I've alluded to this idea that international law isn't just sort of operating on its own, but there are international courts out there that can help resolve disputes between states. And so we're going to talk a little bit now about how these courts have operated, and also a new turn in international justice, which is looking at the prosecution of individuals, particularly for crimes against humanity and other human rights violations. So when we talk about international courts, the place to start is with this idea of adjudication. All right, this is an advanced form of conflict resolution in which you have a neutral third party, a judge, that's going to hear the cases presented by various different actors, um, and that individual is going to provide a ruling, and that ruling can be adopted by parties as a solution to a problem, right? This is different than negotiation, right? Where two actors are sort of working things out on their own. It's different than mediation, where you have a neutral party who's facilitating a conversation and maybe helping to generate ideas, but is really leaving the dispute resolution to the parties on their own to find. With adjudication, the disputants, the actors involved, are giving up control over the outcome. They're making their best case that they can, and then they're handing off to this third party for a solution. And this is something that's been used only for about 120 years or so in the international system. Before that, before the establishment of the International Court of Justice, there really wasn't a mechanism for states to do this kind of thing. The International Court of Justice is the primary mechanism for adjudication in the international system today. It's part of the UN system, but it actually dates back before to the League of Nations, and then even a little bit before that. Typically, there's about 15 judges on the court, of which 5 are always drawn from the permanent 5 members of the Security Council. Right, again, just one more way in which the powerful states are able to interject themselves into international organizations, even international organizations that are doing sort of justice type things. There's a optional statute in the charter for the International Court of Justice that gives, in which states can choose to accept the rulings of the International Court of Justice. So the basic idea is we still have sovereign states, and if they show up and they don't like what the adjudicator comes up with, they can reject the ruling and walk away. But some states have signed on to this optional statute, giving the ICJ compulsory jurisdiction. What that means is that if the ICJ rules and says, this is how you are going to resolve this dispute that you've brought before us, states have promised ahead of time, yes, I will follow through on that. Another place that we see adjudication being used is with regional courts, primarily the European Court of Justice. And again, this is sort of managing disputes within the European Union, where maybe one country feels that a law of another country is in violation of EU governing principles and documents, or perhaps adversely affects that other state. The European Court of Justice would be a place where those issues could be resolved between states on matters of international law. And adjudication is really important for international relations, even though there's only about 2 cases a year that go before the International Court of Justice, right? It's not like the docket is just packed, but it plays a role in helping to build and refine and interpret international law. And when we talked about the sources of international law, one of those sources is the rulings from these courts, right? The documents that judges are generating help other states to understand what's going on with international law, what it actually means on the ground and in practice. And so this is a vital part of making other international agreements workable on the ground. It also gives states a way to head off crisis, right? So if there's a dispute and you feel like you've been aggrieved, and the papers are printing angry rhetoric and it feels like it's escalating, leaders can respond by saying, we're going to take this to the International Court of Justice, we're going to plead our case, we're going to get justice, we're going to get this resolved, and they put it in the docket, and that gives them a year or so, or 2 years, maybe even 3, while it's working its way through this sort of justice system, where that dispute can be maybe managed through regular channels of negotiation and diplomacy, that can allow for states to say that they're doing something and give themselves time to shift out of a crisis mode. The other thing that I think is worth noting about the International Court of Justice is that even though there's only 2 cases or so a year, there's a lot of unobserved effects, right? If two countries disagree about what international law says and how it should be interpreted, then when they go to the International Court of Justice and they start preparing documents and looking back and making their case, one country might realize that they're actually in violation of international law, that there was an angle that they weren't considering, or they recognize that they're going to lose the case, and they may pull it before it actually reaches the docket of the International Court of Justice, because they've shifted gears from one of confrontation or not responding to requests for change, and instead shifting to be more in compliance with international law. So that would be a successful example of these courts changing state behavior, even though it's not showing up on the docket. Another place where we see that is that when there is a dispute that reaches the International Court of Justice, it's probably because there's a real gap in international law. And when the International Court of Justice rules and says, okay, there was this gap in international law, we weren't exactly sure how things apply in this new circumstance, but this is what we think should be done, and this is the ruling that we're going to come up with. Other states who are maybe in similar circumstances are going to look to that and they're going to say, oh, okay, we've been interpreting things incorrectly for a while now, but now we have greater clarification and we can adjust and shift our behavior. And so there might be all of these other sort of peripheral effects of each International Court of Justice ruling that don't necessarily show up, but still help to make the entire ecosystem of international law functional. When we talk about individuals and international justice, we're shifting gears a little bit. All of the adjudication bodies that are out there in international law, from the International Court of Justice to the World Trade Organization to the European Court of Justice, those are about disputes between states over what international law means. I, as an individual, I can't go to the International Court of Justice and get redress for wrongs or to try to make the United States comply with international law. That's not an option. The International Court of Justice doesn't interact with me, but there are human rights courts and international tribunals that do look to individuals as both a source of where grievances can come from. You as an individual were harmed, and will also prosecute individuals. And so I think it's worth thinking about some of the history of international courts dealing with human rights issues. So war crimes tribunals and I guess human rights courts were used after World War II to try Nazi Germany and Imperial Japan for the crimes against humanity committed during World War II as part of the war crimes, right? So attacking other countries, but also crimes against humanity, right? The Holocaust and the brutality of the Japanese occupation. Those were treated and charged as war crimes and crimes against humanity. But after the prosecutions at Nuremberg and elsewhere after World War II, the sort of international tribunal system sort of wound down and was sort of gone for a couple decades, and was revived again in the early 1990s when the international community was looking at a series of atrocities and human rights abuses in the former Yugoslavia and in Rwanda, and looking for some mechanism to kind of respond to some of that horror and violence that would possibly address that. And so whether we're talking about the Nuremberg tribunals, the World War II tribunals, or the tribunals for Yugoslavia or Rwanda, there were some common elements. One is that there's an idea that these international courts should be focused on the leadership of states, that the private in the field who's carrying out a horrific human rights abuse, that person is culpable, certainly, and certainly has committed a war crime, but there's limited bandwidth for the international community to pursue these things. And so the focus should be on the officer corps, the focus should be on the political leadership, the focus should be on the people who actually have political leniency and power to be able to change things. So there's a focus on leadership. There's a little bit of a concern with these tribunals that they've been kind of ad hoc. They were sort of thrown together after the fact, or maybe without fully fleshing out what are the rules of evidence going to be, who's going to be allowed to testify, how is that going to work. And so there's been a lot of messiness from the perspective of these sort of ad hoc tribunals, and they've had sort of a taste of victor's justice, right? That while the crimes of Nazi Germany and Imperial Japan were indeed horrific, the United States engaged in firebombing and The occupation of Eastern Europe by the Soviet Union was also brutal and horrific. And those crimes were sort of left outside of the scope of what was considered a war crime and what was prosecuted after World War II. And so there emerged in the international community a sense that maybe something else was needed, something that would be a little bit more permanent and would be able to have greater legitimacy. And so in the mid-1990s, the international community began a series of negotiations to take the international tribunals for Yugoslavia and Rwanda and to convert them into a permanent court, an international criminal court, which was laid out in the Rome Statute, the founding agreement behind that. It's been the Rome Statute has been ratified by more than 100 countries. It's now in effect, and the International Criminal Court has been prosecuting individuals who've committed war crimes and crimes against humanity. There are other human rights courts as well, but all of these courts, whether we're talking about war crimes tribunals or the International Criminal Court or human rights courts, operate on principles of complementarity, right? And what that means is that these are not a replacement for domestic justice systems, that the appropriate place to deal with war crimes or crimes against humanity is within the domestic sphere, right? And so if there are, crimes against humanity or war crimes committed by U.S. soldiers, individuals who might have targeted civilians, for example, those individuals should be prosecuted under the Uniform Code of Military Justice for violation of military rules derived from the Geneva Convention, and that individual would be thrown in prison for committing a war crime. That's the way it's supposed to work. The International Criminal Court and other human rights courts exist when that kind of a system is broken down. And it might have broken down because of just out and out state collapse, right? There isn't a functioning justice system that can possibly bring people to justice because war or destruction or chaos has just completely eroded those foundations. So it's complementing the domestic justice system in the sense that the domestic justice system is no longer in existence. The other place where these courts might have jurisdiction would be if the domestic courts are declining to act for reasons that maybe smack of corruption, that perhaps there's no possible mechanism for an individual to get redress of wrongs, for an individual to be put on trial for war crimes and actually be convicted because the justice system is twisted in some way. In that situation, then the International Criminal Court and other international human rights courts function as sort of a backstop, and they can step in and prosecute individuals. I should give a little bit of backstory on the scope of the International Criminal Court because it's something I think is maybe not well understood, and particularly in the United States, there's I think a political panic about it that isn't entirely justified. So when the Rome Statute was being negotiated, Bill Clinton, president at the time, signed it and said that he wanted to lend the moral weight of the United States to the International Criminal Court, but he didn't expect the United States would ratify it. In fact, he didn't even submit it to the Senate for ratification, knowing full well that it would not pass through and get the necessary 2/3 vote in the Senate. When George Bush Jr. became president, one of the first things that he did as president was to unsign the Rome Statute on the grounds that he didn't want to give the moral weight of the United States to the International Criminal Court. And the argument that was put forward was that the International Criminal Court could become politicized and could be used as a forum to go after the United States and specifically soldiers carrying out operations that might be prosecuted unfairly. I think this is a little bit overstated as a concern for a couple of reasons. For one thing, the International Criminal Court only has jurisdiction over countries that sign and ratify the International Criminal Court's founding statute, the Rome Statute. Without that, the International Criminal Court doesn't have jurisdiction. There is a mechanism for states to be brought under the jurisdiction of the International Criminal Court. The UN Security Council is granted the authority to give the International Criminal Court the power to investigate war crimes and crimes against humanity. That happened in Sudan. Sudan did not sign or ratify, but the International Criminal Court was given jurisdiction to prosecute crimes against humanity by the UN Security Council. So that's possible in the case of the United States. But again, the United States has a veto on the UN Security Council, so that strikes me as a very unlikely sort of thing to happen. There is, however, the possibility that US soldiers or politicians who are operating in a third country that has signed the Rome Statute might fall under the jurisdiction of the International Criminal Court. And as it looked like the International Criminal Court was about to reach the necessary hundreds states signing and ratifying for the thing to come into effect, the Bush administration pulled out a full court diplomatic press to delay the International Criminal Court from coming into effect and putting in place a series of bilateral non-compliance agreements with states. It's unclear how many of the states have actually set up these agreements with the United States. It could be around 40. Oftentimes they're kept secret, but they're essentially agreements that say, even if the International Criminal Court issues a arrest warrant for an American citizen, other states will not comply or assist in helping to execute that arrest warrant and deliver an individual from the United States to the International Criminal Court. So the US has built this entire infrastructure to insulate itself from the International Criminal Court, which normally would be fine given that the US military justice system is fairly robust, but it's still, I think, a point that needs to be well understood in terms of how this whole thing works and relates with the United States. When we think about the prosecution of individuals for war crimes or crimes against humanity, there's a couple scenarios in which this gets used, and I want to flag a fairly important development that's emerged out of this. So this tends to be used against dictators who are either in power or out of power, and it could be through the International Criminal Court, it could be through domestic courts, it could be through foreign domestic courts. It's also used against combatants during and after conflict. So the International Criminal Court has issued an arrest warrant for the president of Sudan. That would be one example. Domestic courts can also be used. So after the fall of dictators, you may have domestic courts going through and prosecuting regime officials for crimes they may have committed. This occurred after the collapse of Saddam Hussein's regime with the US invasion, that there was a domestic court structure that was set up to try Ba'ath officials. But then you can also have foreign courts that are using their own domestic jurisdiction to try people from other countries for crimes against humanity. And so I think one of the more famous cases of this was Augusto Pinochet, who was getting cancer treatment in the UK when a Spanish court indicted him for crimes he committed as a dictator in Chile. In Chile, he had granted himself immunity as part of his agreement for leaving power. Spain refused to recognize that and claimed that there was a connection to Spanish citizens who had been harmed by his regime, and that gave them jurisdiction to prosecute him. More recently, it looks like Germany is actually using its domestic court system to try individuals for war crimes committed in Syria, and not even making any sort of claim that it has affected Germany or German citizens in some way. They're just claiming universal jurisdiction, that their domestic courts are in a position to be able to bring charges against or to hear cases against individuals committing war crimes anywhere in the world. So there's a lot of different layers to this whole prosecution of individuals thing. It's a fairly new development, and already we're seeing some statistical evidence that it may have entrenched a norm against atrocities, both among combatants and among dictators, that the expectation that there might be prosecutions at some point down the line seems to have some sort of deterrent effect. There's some statistical evidence that when a dictator is prosecuted for crimes committed during his or her time in office, that neighboring states that are also head dictators tend to improve their human rights records, perhaps in an attempt to show, no, I'm not as bad as that individual. Even if I'm pushed from power, keep in mind I treated you all fairly well. And so there's the hope that this is going to help to reduce human rights abuses, both in the short term and in the long term by further entrenching these norms against atrocities.